talked about this issue before, but I'm wondering if we could go on the record about with your position on the idea of cameras in the courtroom.
Well, my position is a nuanced position, sort of reflective of the protocol that you probably had a chance to see, the famous Maverick protocol, or the media, audio, and video protocol that's on our website. We're living in an age now where a certain amount of public confidence requires a certain amount of transparency and accessibility. I mean, that's one of the reasons why I'm trying to present myself to you gentlemen, to present certain things that I am well placed to do as a Chief Justice about the institution that I work in. But on a more operational day-to-day basis, people want, to the extent they can, to see as much of what the court does as they can. Now, if they want complete access, the easiest thing for them to do is come down and watch a case, because in most cases, even I would say in all cases, it's complete categorical public access. There may be moments in time that certain parts of a trial can't be publicized or televised, but it's generally speaking public access. Cameras in the courtroom is something that certainly has evolved to, as a subject, has evolved to the point where now there will be, in those permissible and appropriate cases, access by the media with either video or audio equipment. When I say my position is a nuanced one, it's nuanced because when you look at the protocol, you see certain parameters that are fixed, which reflect, I think, ways to accommodate the media's desire and the public's desire, presumably, to have some of this access that comes with cameras in the courtroom, but at the same time protects against those things that might compromise the integrity of the process. So we're a long way from having cameras in the courtroom, for example, covering criminal trials. There are real concerns by all participants that witnesses might not speak or testify as freely. Certain members of the bar, the judges, or others might not feel secure. Certain aspects of an accurate result might be in some way tarnished. So those are issues that we'll have to deal with if we ever, at some point in time, want to see trials televised. But sentencings by judges and other meaningful events might be televised or at least transmitted in some way. All of that will be guided by sort of the parameters that you'll find in the Maverick protocol. All that's left now is for the media to make these applications, and I appreciate some applications have been made, but I think there's a greater clarity now about what those parameters are. I can never guarantee you a result, because it's always going to be within the discretion of the judge, but I can tell you judges are now more alert to and sensitive to the availability of the protocol to help them guide what it is they may decide to do. At the end of the day, if they determine that more access is required, then that'll trump the protocol, and that would be rooted obviously in some charter argument. But right now, the good news for the media is you can make applications, and in certain circumstances, certain types of cases where the nature of the case and the scope of the coverage is consistent with the integrity of the process, you'll have a shot at getting it televised. It's always, of course, subject to the discretion of the given judge. So.
Now, you mentioned a couple of applications have been made already. I guess most notably in the Brian Sinclair inquest, as well as the Graham James sentencing. I think both were rejected. Often with this subject, we talk about accessibility, openness to the public. Given that consideration, would it make sense to consider cameras in the courtroom as sort of a reverse onus kind of situation where it would be up to the Crown to prove why we shouldn't have cameras in?
But I mean, there is certainly a principle that's called the open court principle. That's a presumption. But even the open court principle allows for certain exceptions and certain stipulations so as to ensure the integrity of the court process and the proper functioning of the administration of justice. So rather than have a reverse onus, I think what you have already in place is this delicate balancing that has to take place by a judge who's doing his or her job responsibly. So that's why I say the Maverick Protocol not only represents the work of the committee about which members of the media served, or from which the members of the media served, but also it represents, I think, a lot of the considerations that are discussed in the case law. So I think you're getting that now. I think if applications are made, you're going to get, at the very least, a very considered as I think you did in the cases that you mentioned, and the results might have been disappointing to the media. I appreciate that, but I think you're going to get very, very rigorously considered reasons from the judge for or against access with cameras. But it's important, I think, that the media understand, though, that the protocol is there, and if you look at it, it's pretty nuanced, and that doesn't mean you can't push it a bit. I mean, it'll be up to the judge. But the good news is there is this new form of access that you can attempt to get, and in those circumstances where it's appropriate, you'll get that stipulated access.